Hello and welcome to Support Through Court's online event in honor of International Women's Day 2023, Elevating Women's Voices in the Legal System. Tonight we're here to talk about women's access to justice, and we've got some wonderful panel speakers, some of which are ready and waiting to delve into the discussion. We've got Claire that's just joined us. Hello, Claire. When your screen comes on, you'll see that you're already live in the webinar, so don't panic. It's all okay. Hi. I'm just doing the intro. So yes, we're waiting for one more panel speaker, but I will introduce her when she arrives. So my name is Melanie Batcher Samuel. I am a family law solicitor, and I am the founder of MBS Family Law. I also fundraise for Support Through Court through the FAB, so the Family Ambassadors Board, which specializes in we've been set up to basically fundraise within the family law world. So there's about 5 or 6 of us, and we try to think of ways to increase the profile of Support Through Court and find ways of fundraising. And tonight I'm chairing this panel. If you're here this evening, odds are you probably know about the wonderful service that Support Through Court provides. But for those of you that aren't yet acquainted with Support Through Court, or for those of us that perhaps want a reminder of the wonderful work that Support Through Court does, and it's wonderful and important work, I'm just going to run through some important or useful facts and figures just to get you thinking about the charity. So every year, thousands of people in the UK face court alone. Often it's not a choice that they make. They're forced to do this. They have to represent themselves at a moment in their lives where something really big could happen to them. We could change the whole course of how they live their lives. It could be a divorce. It could be they're facing eviction. It could be they're about to lose their child. It can be a really big decision. And in an unfamiliar courtroom, the process can be stressful and confusing. Support Through Court is a charity that exists to empower people facing the family and civil courts without representation by providing them with practical and emotional support. And that can be assisting them with really basic things like, basic for some people, but actually really complicated for others, completing forms. Understanding legal jargon, calming their nerves down when they're about to walk into a courtroom, sitting in there and taking notes with them. There's a whole raft of things they do which make a huge amount of difference as to whether someone is properly able to access justice or not. And Support Through Court provides a free service that offers support and guidance just before, during, and after court. Hannana, hello, you've joined us. Hello, we're live. I'm just doing a brief introduction and then I will introduce all the speakers. You're okay.
Yeah, brilliant. I don't think you can see me, can you?
We can see you. We can see you. We can't see Claire though, but we can see you.
Okay, great.
The final thing I'd like to say about Support Through Court is that there are over 500 volunteers across the country. And they're based in universities, in court buildings, and through the national helpline, telephone line, to help as many people as possible. There are some amazing volunteers, and considering the work they do, they're just a brilliant charity. And as a lawyer, I've come across them in courts. I've come across them when I was volunteering with the Citizens Advice Bureau. They are absolutely brilliant. And this is why I'm really happy to be chairing today's panel. So on to tonight's event, which is why we're all here. So over recent years, there has been an influx of reports about violence against women, but often we fail to hear about the journey that these women go through while seeking justice following the crime. So our expert panel is here to discuss the experiences of women in the legal system and how we can continue to elevate the voices of these women so that they can feel empowered to seek justice. Our panel is here. All here present, and they consist of Claire Waxman, who is London's first Victims Commissioner, Dr. Charlotte Proudman, who's an award-winning barrister focused on women's rights and justice, Dr. Hannana Siddiqui, the head of policy and research at the charity Southall Black Sisters, Lucy Hadley, who is head of policy at Women's Aid, and Mandip Ghai, the senior legal officer for the charity Rights of Women. So hello to all of you. Thank you for agreeing to be here. Normally what I would do here is I'd do what lawyers usually do, which is I'd say, I found all this wonderful stuff online and I'm just going to regurgitate their bios. I don't think that would do you guys justice. We don't have the time to set out all the interesting and impressive things that each of you have accomplished. And nothing I say is going to live up to the incredible work that you guys are doing every single day. So what I would like you to do, and I'm all about giving women the opportunity to talk about themselves. I don't think we do it enough. So I'd like each of you to introduce yourselves to the audience. I'd like you to explain what you do, so who you are, where you're from, what you do, and then to finish off by telling us one positive thing that's happened in your workplace recently, or that's happened to you, full stop, that's a positive that you'd like to share with the audience, just to kind of set us in for the conversation. And I'd like to start with Lucy. So Lucy, if you can unmute yourself and introduce yourself for the audience.
Thank you very much. I'll try to remember each point that I need to cover. Hello, everyone. It's great to be here tonight. I'm Lucy Hadley. I'm Head of Policy at Women's Aid Federation of England. Many of you might know Women's Aid. We're a national charity working to end domestic abuse against women and children. We have sister federations in Scotland, Wales and Northern Ireland too. And we're made up of 170 local domestic abuse organisations who deliver life-saving support to women and children across England. Sorry, the second point was
what you do, and then one positive thing.
Yes, great. So I'm the head of policy, so I oversee all of our kind of policy development and positions at Women's Aid. Of course, as you'll be aware, domestic abuse cuts across so many different issues. It's not just a criminal justice or a family justice issue. It affects a woman's housing, her employment, her children, their education, their schools, her health, her physical and mental health, so many different areas. So policy at Women's Aid is very broad and covers a broad range of issues. I work with many other violence against women and girls organisations, some of whom it's great to see here tonight as well. And I lead on our engagement with the different agencies that survivors interact with. So whether that's the police, the NHS, the courts, all of those kind of different systems, I lead on engaging with them. In terms of a really positive thing that I wanted to share, we are celebrating International Women's Day tonight, and we had an amazing event internally at Women's Aid last Wednesday, where an ex-Olympian called Michelle Griffith-Robinson, who you may have heard of, came to speak to Women's Aid. She's one of our ambassadors, and she was an Olympian triple jumper, and she came to speak to us about her about her experience of domestic abuse, why she's an ambassador for Women's Aid, and why, and how women can support each other. So that was an amazingly positive thing to kick off International Women's Day with.
Oh, that's great. Thank you, Lucy. Thanks for sharing that. Next person is Charlotte. Over to you.
Hi, everyone. Thank you very much for inviting me to come and speak with you and share a panel with all of the amazing women that do life-saving work on a daily basis. It's really wonderful to be here with you all. And thank you as well to Support Through Court and the fantastic work that you do, because so many victims of domestic abuse feel understandably left behind and let down. So I am a barrister at Goldsmith Chambers, and I specialise predominantly in family law in cases of rape, domestic abuse and coercive and controlling behaviour. I also run a not-for-profit called Right to Equality, where we are researching the changing potentially of the presumption of child contact with rapist parents, predominantly fathers. And something a little interesting. Well, last week, actually on International Women's Day, there was a judgment published, which I represented Women's Aid, Latin American Women's Aid and Refuge, as instructed by Rights of Women in that case. And it was an incredible judgment by the president of the Family Division. If you haven't read it, I definitely encourage you to look it up. And it's an amazing judgment for two reasons. One is that it's one of the first, if not the first, judgments that defines intersectionality, which is absolutely incredible, because I have been asking judges to do that for a really long time, to spell out what intersectional inequalities actually are. And some judges have looked at me blank and don't understand apparently what that is. And the second reason that it's important is that finally it sets out guidance on how court orders should be served on victims of domestic abuse who are living or staying in women's refuges, to make sure that they are safe and that the address of women's refuges remains confidential. So that judgment and those two things that stem from that, particularly concerning migrant women, is incredibly important. Thank you.
Thank you, Charlotte. That is really interesting. Obviously, family law world, all up about it, talking about it. It's all everywhere on social media. So very interesting and very simply put. Thank you very much. Mandip, can I ask you to introduce yourself, please?
Hello. I hope all you had fun celebrating International Women's Day last week, and I'm very happy to be here today. So Rights of Women is a charity. We were founded in 1975 by a group of women lawyers. Our mission is to achieve justice, safety and equality in the law for women. We do that in various ways. One of the ways we do that is we deliver free legal advice to women over the phone. The advice is delivered by qualified solicitors and barristers who either work at Rights of Women or are volunteer lawyers. So we have up to 50 solicitors and barristers giving up their personal time to advise women on our advice lines. We offer advice on 4 areas of law: immigration and asylum law, sexual harassment in the workplace, criminal law and family law. I'm a senior legal officer in the family team, and so my background is in family law. I practiced family law, doing mostly legal aid work before I joined Rights of Women in 2014. So we hear about women's experiences through the justice system every day on our advice lines, and that's probably what we're talking about today. Something positive, I was going to mention the same case that Dr. Charlotte Proudman just mentioned. Obviously, we were so pleased about that in our Rights of Women. So I'll think of something else to say instead. One thing that I'm feeling positive about is we're working on, in addition to the telephone advice lines, we're working on a new online platform for women to be able to contact us and ask us their questions in relation to family law and criminal law, and we're hoping to get that launched at some point this year, and we're working with a group of survivors to develop that.
Thank you very much, Brenda. That sounds really interesting, because it must be so much easier to be able to do something online. You don't have to be speaking. You can hide your screen. You can have easier. Yeah, that's
yeah. It's not going to be telephone and the online. It's not going to be perfect in terms of access, but it's hopefully increasing access to the service.
That's great. Thank you for that, Dr. Hannana Siddiqui. All over to you.
Hi everyone, I'm sorry I was late. I had to get back from another meeting. Yeah, I'm Hannana Siddiqui. I've been at Southall Black Sisters for about 36 years, and I've done every job in it. At the moment, I am the head of policy campaigns and research, but I've done a lot of frontline work as well. And Southall Black Sisters itself it's a women's resource centre. It's a buy and for service for Black and minority women and migrant women on gender-based violence. We do a lot of service provision, advocacy in particular, but also counselling, support groups, helplines. And we also do campaigning and policy work. And our current campaigns, there's 2 campaigns, one around migrant women who have no recourse to public funds. So the campaign is to ensure they have public funds. And the other one is around, well, it's a mixture of honor-based violence and forced marriage and issues around that. And good things, there's been, it's been hard work, but there's been a few good things. I can mention more than one. I mean, we've been accepted as core participant in the COVID inquiry. We were refused legal aid, but now we won our appeal. And we also got the judgment on transnational marriage abandonment, a positive judgment on that we've been working on in the past. And I heard something today about migrant women, which I can't tell you yet, but it's good news. Yeah.
Oh, thank you. That's a lot. I like hearing lots of good news. It cheers me up nicely. Thank you for that. And finally, Claire, can you hear us?
I can. I don't seem to have access to a video. Yeah, video doesn't allow me. I don't know if you can see me.
No,
No,
but
no.
Celine, I don't know if Celine, who's in the background, maybe can do something, but if not,
Okay.
go ahead verbally.
I don't
we'll listen
mind.
to
You can look at everyone else. I'm very happy just to speak and look at everyone else's
Excellent.
lovely faces. But thank you so much for inviting me. And yeah, it's wonderful to be with all the other panelists who I know very well and have huge respect for. So I'm Claire Waxman. I'm the Independent Victims Commissioner for London. I was appointed by the Mayor Sadiq Khan coming up to, well, 6 years ago now. My role is very much focused really on the criminal justice system, so when victims report and want to come forward and access justice and support. So it's about amplifying their experiences and their voices to try and identify and challenge any barriers that they're facing to access justice. So there's a lot that we've done over the years to try and make improvements. I'll be talking about some of it shortly, but if you want me to sort of pull out something very positive, we had a really good win only a short few weeks ago around something called the home detention curfew scheme. So when someone's been convicted, there are certain crime types that are eligible to come out under early release under the home detention curfew. And something I've been campaigning for a number of years to change was to ensure that domestic abuse, stalking, coercive control, all related offences were not eligible under this HDC, but that took a long fight, many years, and I'm pleased to say that if someone is convicted for domestic abuse related offences, stalking, coercive control, or is subject to restraining order, they are no longer eligible to come out under early release under the home detention curfew. So that gives a extra protection and support to those victims. But that was many years of a long fight to get something as small as that change with that scheme. But yeah, just wanted to say that we got that a few weeks ago. But I'll be talking more in my speech about other things that we've worked on over the years.
Thank you, Claire. That's fascinating. I'm always amazed when I hear the amount of time that people give to these things, and then it happens and you think, wow, that just seems so easy. Oh, hey, Claire, we can see you.
I think it's, yeah, I wasn't in as a panelist, so now I'm in. So
perfect. It always feels like, oh, it's so easy. They've got this one. And then you think there's a lot of hard work that gets there for an amazing result. So congratulations to all our panelists who are working day in, day out to get these amazing results that we hear about and think, oh, yeah, great. And it actually is a lot of work for a lot of people. So thank you. Thank you for introducing yourselves and for giving me some positives to look forward to. I'm now going to ask you to start the discussion. So what I wanted was to ask each of you for your thoughts on the experiences of women in the legal system. And you've each given me ideas or angles that you want to be discussing. So what I'm going to do is I'm going to give you each 10 minutes, maximum of 10 minutes, to talk about your points. And then after that, once you've all done your bits, I will ask you each or together, however you want to do it, to tell me if you think there's things that we can be doing to continue to elevate women's voices so that they feel empowered when seeking justice. It may be that you already discussed that in your speeches, and in that case, that's fine. But if you haven't discussed it or you just want to raise it, we can always mention it at the end. And don't hesitate to jump in if you've got questions of each other or comments you want to interject. Please jump in. And I know that some of you might have to leave a little bit earlier, so if you want me to rejig the structure, I can do that as well. Just put your hand up and I will move things around. But at the end of all that, I will see if there's any questions from the audience. So I think Celine will let me know if there's been anything that's come in the Q&A. You can, for the audience members, put in your questions in the Q&A and it'll come up and we can deal with those then. So let's start with Claire. You wanted to talk about, or you told me you were thinking of looking at privacy rights in cases of sexual violence, independent legal representation for victims, and barriers to justice for victims. Over to you.
thank you. And again, thank you so much, Support Through Court, for marking International Women's Day and for doing this event this evening. And as I said earlier, really, love sharing the space with the wonderful lineup of expert speakers that we've got on. I've worked with many of them before, so it's always great to see them. And as I said, I'm going to focus more on the challenges women are facing really in our criminal justice system, and the ways in which women are really trying to push back and advocate for change and to make sure their voices are heard, which is what my role tries to support women in doing. So in my role as the Victims Commissioner for London, I've had the opportunity to meet with and learn from many women who've tried to use our legal system to seek protection and justice, not just for themselves, but also for others after experiencing violence and abuse. Unfortunately, many of these women repeatedly tell me how their rights as victims of crime are not being upheld, and there are rights loosely given to victims at the moment under our Victims Code of Practice, which is pretty toothless. It's not legally enforceable, and it's why I've been campaigning for a victims law for over a decade, and we are waiting for government to still bring forward a victims bill. Victims talk about how they're not respected during the process, and that in some cases the legal system itself has become a barrier for them accessing justice and recovery. There are many areas within our legal system that need to change to address the concerns that we hear repeatedly by women and girls who experience crime, some of which I think will be covered by other speakers here this evening, but I just wanted to take the time this evening just to focus on some specific areas, namely the concerns raised by victims and survivors of rape, domestic abuse, and other forms of gender-based violence. Back in 2019, I completed the first London Rape Review, which was a comprehensive review of allegations of rape and watching rape cases through the criminal justice system. That rape review made a significant contribution, I think, to our understanding of how rape cases were being so poorly handled in the justice system and why so few cases were resulting in both prosecution but also conviction. At the time, in the 2019 review, it found that only 6% of allegations were reaching trial, with only 3% resulting in convictions. 58% of victims that were reporting to the police were withdrawing from the justice process. And I did a subsequent rape review, London Rape Review, in 2021, and by that time the withdrawal rate had gone up to 65%. 64% of rape victims were withdrawing within 30 days of reporting to the police. The average length of time from the date of reporting to the police and the trial outcome was 18 months, which we thought was terrible at the time, but I have to say now looking back, that's much more positive than where we are now, because that figure has sadly been extended and really exacerbated by the pandemic, and we now have record Crown Court backlogs. The review shone a light on a number of systemic issues, including rape myths, stereotypes, and how they're influencing police and CPS decisions, deciding about the credibility of victims, the viability of cases. Also, there were delays in case progression, and most concerningly was disclosure and the intrusive access to victims' personal data, and barriers to access timely information, and overall lack of trauma-informed support for rape victims. As I mentioned, in 2021, I published further research, and this is in the form of a second rape review, which was to gain a better understanding, a more in-depth focus on examining the prevalence of requests for victims' mobile phone data. And I just want to read you, because with all my work, I always try and bring the victim's voice whenever I'm talking. So I just want to read you a direct quote from one of the rape survivors that we spoke to for the second London Rape Review that we did around mobile phone data and third-party materials such as medical records and counselling records. So this is a quote from a rape victim. "Despite the fact I was raped by a stranger who was identified many years later by DNA evidence, I was then told that in order to charge him, the police would need to go through my school and university records, medical records, and around 6 years of therapy notes. This felt so invasive and disturbing, as if rather than assessing the evidence gathered at the time of the rape, they were evaluating my character over my lifetime. I felt I had very little power to object to this, as they warned me missing information would jeopardize the case. The extent to which I was expected to give my life over for inspection and judgment eventually led me to decide that were the case to go to trial, I would withdraw from the process as I was terrified of being subjected to further scrutiny and my life experiences and private therapy notes being used to discredit me. In both my London rape reviews, on the back of obviously the evidence that we got from the research, but also listening to victims and survivors, was to strengthen the victims' rights to privacy in relation to these intrusive requests for the third-party material, specifically counselling records. I also highlighted my concerns to the Information Commissioner's Office back in 2018 with the support of a number of organisations, some of whom are on this call this evening, about this excessive collection of victims' personal data and how vulnerable victims have no choice but to waive their rights to privacy if they want their case to progress. Now, as a result, in 2022, the ICO officially called on the criminal justice sector to immediately stop collecting excessive amounts of personal information from victims of rape and sexual assault. And the Commissioner's report highlighted that there is a lack of understanding in our criminal justice agencies of data protection law and how it applies to sharing victims' information fairly and lawfully. Now, this is an urgent issue that must be addressed if we want to improve the confidence and experience of women reporting crime and bringing dangerous offenders to justice. And I've been campaigning for the government to strengthen victims' rights to privacy in the draft Victims Bill, so that victims are not being unnecessarily subjected to intrusive requests for information that ultimately will lead to them withdrawing or discourages them from reporting the crime in the first place. Now, we have seen some positive progress. There was a new code of practice on mobile phone data extraction included in the Police Crime and Sentencing Bill, something I campaigned with the then National Victims Commissioner, Dame Vera Baird. However, to ensure that this code is adhered to, we've also requested that the Victim Bill establishes the right for victims of rape to access free, legal, independent representation when their records or personal data is being requested, so that we can ensure that those requests being made by the police and the CPS are strictly necessary and proportionate and do not curb their access to justice. I'm pleased to say that a pilot is about to commence in London, which will actually trial the delivery of this independent legal advice to rape survivors, with a focus on access to mobile phone records and third-party material. So I'm really going to look forward to how that pilot works and the evaluation of this pilot project. Strengthening rights to privacy is essential when it comes to counselling notes. There is a legitimate fear for victims of having their counselling records shared with the police, the CPS, and potentially being used in court, which can deter victims from accessing vital services to help their cope and recovery. We're currently seeing a shocking delay in backlogs in the court system. So these issues can lead to victims and survivors waiting many years before they obtain the therapy that they need for recovery. And I believe the Victims Bill must recognise a victim's right to seek support without fear this will be used against them in court. And we know from other jurisdictions that this has been implemented without any issue, without any controversy. I recently met with the Western Australian Victims Commissioner, and they have a total ban on accessing victims' counselling notes. So I'm more convinced than ever that the implementation of this in a victims' law is easily achievable and will be a significant boost to victims' rights. And there's an excellent campaign that's being currently run by the End Violence Against Women Coalition, Rape Crisis, and the Centre for Women's Justice, called Keep Counselling Confidential. And I'd really encourage everyone to look at that and support that further. The impact of low prosecution rates in rape and DA and stalking and harassment offences in which women are primarily victims extends beyond the issue of access to justice for women, however important this is. We've seen high-profile cases, including serial perpetrators such as John Warboys, Wayne Couzens, and David Carrick, that when cases are not taken up or taken forward, or being dismissed and not taken seriously, dangerous offenders are being left to repeat their abuse for many years or escalate to the most serious of offences, which put women and girls at unnecessary risk of harm. So when these cases do come to light, it impacts on women's confidence in our legal system and the crucial relationship between criminal justice agencies and victims. But there's another impact that I want to highlight quickly today, given the remit of support at courts work, and this is the impact on family court outcomes. there's a significant disconnect between the worlds of our criminal justice system courts and our family courts. And this is leading to family courts misunderstanding that if we see police take no further action on a case, or if there's an acquittal involving rape or domestic violence, it's seen as evidence of a false allegation when it comes to the family courts. And what we're seeing is if the criminal justice system is not taking the right response and not getting cases to court, and we're not seeing convictions, then this is actually leading to victims then be treated as perpetrators in the family court and being accused of alienating their children from the other parent, usually a father. And these allegations or claims are often supported by unregulated psychological experts who have no understanding of the dynamics of abuse, no understanding of domestic abuse or rape or coercive control or trauma. And so in extreme cases, we have encountered situations where this has resulted in children being removed from the safe parent, usually the mother, and being forced to reside with the abusive parent. I, along with others on this call, have supported calls for there to be stronger safeguards within our family courts to prevent these unregulated experts from influencing judgments in these cases and making life-affected judgments. We're eagerly awaiting the review by the Ministry of Justice, due to be published this year, into the legal presumption that continuing involvement with both parents is always in a child's welfare. Last week, on Friday, I invited the Minister of Justice from Quebec, Jolene Barrette, to speak at my Victims Summit, and Hannana was there and a few others as well, and Hannana was speaking. And he actually mentioned family law reform that was taking place. They've introduced Bill 12, which ensures that when a child is born following a rape, or the mother is a victim of rape, the victim can deny the perpetrator parental rights to this child while still being able to access child support. And I, along with some others on this call, will be calling for a similar right for victims of rape and domestic abuse in the upcoming Victims Bill. I've already supported the calls for Jade's Law, which is to ensure that when a parent kills the other parent of their child, they automatically have their parental responsibility rights suspended. But I'd like to see this extended so that if a perpetrator is found guilty of rape or domestic abuse, or there is a finding in the family court, they are therefore that refuses access to children, victims may request a suspension to parental responsibility rights without this negatively affecting child maintenance. Women are primarily victims of rape and domestic abuse, and they are far more likely to be primary carers for children. So addressing the multitude of failures in family courts and how they respond to domestic and sexual abuse is an urgent equalities issue, and it's critical if we're going to better safeguard children who are both the direct or indirect victims of crime. I'm very grateful that Support Through Court and other victim survivor services, some of whom I think are here this evening, are working so hard to support women through these difficult and complex journeys. Just want to briefly touch, and I'm sure Hannana is going to go into more details on this, there's just a lot to say on obviously lots of systemic issues, but one in particular is around the need of a firewall. For police sharing. Currently, police share victims' immigration status with the Immigration Enforcement and the Home Office. And I, alongside Hannana and others and her colleagues at Southall Black Sisters and the brilliant Step Up Migrant Women campaign, have been campaigning for a number of years to end this. And so I hope others will join us in supporting these calls so that we are able to ensure that all victims of crime, regardless of immigration status, have safe and secure reporting to the police and to support services. So I just want to say thank you for the invitation to speak. Very happy, obviously, to answer questions at the end, and just so pleased that this event is happening to improve awareness and understanding of the experience of women and girls, because it's absolutely critical if we want to enable meaningful change for women in our legal system now and in the future. So thank you.
Thank you very much, Claire. Thank you. Hannana, would you be willing to be the next speaker? I think you want to talk about the barriers to justice for Black, minority and migrant women that have been affected by domestic abuse. Or do you want to talk about
I mean, did you? Yeah, yes, I do. Yes. Do you want me to talk about criminal justice system or the family justice system? I don't know, but I'll talk a bit about both. I mean, Southwell Black Sisters, we are a holistic service for Black and minority women facing gender-based violence, and our role through the justice system, well, we do end-to-end work and beyond that. So we help women to report abuse and then help them to navigate the legal justice system and then deal with the aftermath, help them, you know, post-trial, post-hearing, to deal with all the fallout and, you know, particularly if they've lost, but also if they haven't, they still need ongoing support. And so our role often in court can be to support the victim. And sometimes we have to advocate for the victim, sometimes as a Mackenzie friend, but sometimes just with the lawyers and the courts themselves, because if we feel that the survivor is not being treated well or they're being denied certain rights, we're having to speak up. And often we're having to do it in terms of, for example, if they haven't got proper interpreters, or if it's a very bad interpreter, or if there are security issues. You know, the amount of times you turn up either in a criminal case or in a family case where in an Asian family that you have the whole extended family of the perpetrator turning up, and not just the extended family, but also the community. And you're often quite vulnerable as the victim. I know that, you know, there are, you know, security, you know, can be put in place, but actually in a small Crown Court or in a small hearing, which is, you know, not necessarily a murder case, but in a hearing which is kind of routine cases, there isn't that same level of security. And so it could be for the worker, but also for the victim, that there are problems. But also the reason why they're all there, it's not just to frighten you, but also not just to intimidate, but to influence the court, the thinking of the court. Of course, they can't go into a family court hearing, but they can hang around outside. And this is part of a long-term process, a wider process, where women from Black minority communities are intimidated to drop charges, to drop or to drop legal cases around children and non-molestation orders and so forth, or, you know, the contested hearings, matrimonial hearings of financial settlements and so forth. And usually they come under pressure to not only to drop it, but also to reconcile to an abuse, you know, return to an abusive relationship. So there's many cases where I've had to deal with all those pressures even before we got to court. And, you know, there is a high rate of withdrawal, but it's not just because women decide to withdraw, and there is pressure on them to do so, but also because the system fails itself to deal with their specific needs and to support them through the legal system. So we're also there to advocate for their rights, to make sure that they get the support and their needs are met in court, but also we're there often as experts, because there's really not many experts in Black and minority communities who have a knowledge around you know, Black and minority women and gender-based violence. Sometimes we may be there formally as an expert if the courts allow it. Other times we're there kind of informally and trying to influence things anyway, at least thinking of the lawyers, because really I don't know what training judges get, right? It kind of, both criminal and family court judges, it's kind of shrouded in mystery. We don't know what they really fully understand about the issues. And, you know, at times, yes, there's a good, you know, you can tell when there's a good hearing and there's a judge who is really listening to the arguments and taking on board what you have to say. But then there are other cases where, you know, they're not, you know, either a criminal or a family case, and you're kind of worried what you can do. So, like, for example, in both cases, actually, we often asked to go into court with the victim as victim support, and, you know, the defense, the other side, the perpetrator would, you know, object to us being there, and we have to then really convince the judge that there is a role with there, when you can't just substitute us with victim support or witness support, that, you know, we have a specific role and we're not there to coach the victim. I think the one thing that they would often argue, you're there coaching the victim, or you're creating an, you're actually telling them in court what to say. I mean, I don't know how you do that, but that is kind of some of the arguments that have been made. And really, we're there to reassure the victim, to make sure that they are feel confident to be able to speak up in court. Now, of course, a lot of women from the Black minority community don't actually end up in the criminal justice system. They don't report the abuse. In the family system, they may be more likely to go through the family legal system because they want to sort out, you know, matrimonial issues, non-molestations order in children. And sometimes they're forced to go to them because of the perpetrator's application for contact or residency. Whereas in the criminal justice system, you know, a lot of migrant women, for example, may not even go to the police in the first place because they're frightened that their data will be shared with immigration enforcement and they could be subject to removal. And instead of being safeguarded, and this is true for many cases, instead of being safeguarded from the police, they're treated as immigration offenders and are therefore very reluctant to go. But they're also very reluctant to engage with any legal system, whether or not it's criminal or family or civil courts, because they are worried about, you know, they lack the confidence, they don't have enough support. It's a particularly if you're a migrant, you don't know the system in this country. You don't even know most things about what your rights are in this country. You don't know, you're often told by the perpetrator that actually as a migrant, you have no rights in this country. And, you know, I can take the children away from you, or they might they may not even use your immigration status against you. They might use a cultural or religious argument. And they might say, well, actually under Islam, I have rights. You know, under Sharia law, I have rights of the children. And therefore there's no point you using the system in order to get them. And I think that obviously they need to be advised and supported to be able to deal with that, which we do that. But I think a lot of women are prevented from using the system because of if they don't have the support that they need and the specialist support that they may need, somebody who could really explain, you know, who could deal with the cultural and religious arguments, and who can then also reassure them about immigration, their immigration status. Although having said that, we can never really give 100% reassurance on that they will get the right to stay in this country. All we can say is that if you report it, we will support you, we'll get you an immigration lawyer, and we will help you to get your status. But there is no guarantees. And because there's no guarantees, women don't necessarily want to come forward. And that is why we want that firewall to prevent that data sharing, to encourage more victims to come forward and be safeguarded. Now, in the
2 minutes.
Oh my God. Oh dear. So just to say, in just the expert role, I think that you've talked about parental alienation as the expert. You know, there's whole arguments around that. And of course, parental alienation is an issue in many family cases and routinely. And I think that where the courts have really got to understand is that actually they've got to bring in the right experts. They're not necessarily all regular. We're not regulated, right? But we do go in and talk about the impact of abuse on women from Black minority communities. But sometimes the courts get other strange experts. Like in one case, they got a Muslim priest, an imam, to come in to argue for the perpetrator, to say that actually in our culture, I should have custody of my daughter because when she grows up, I want to arrange a marriage. That's our tradition. And the mother is too westernized, and therefore she's not going to pass on our traditions to her. And really, already he was a conservative, violent man. And really all he was talking about was forcing his daughter into marriage in the long term. But the courts were actually entertaining the idea of using him as an expert. And I think that those kind of things need to be really challenged in court. And so there is a role for experts, but obviously the right kind of experts and the appropriate experts. There are other issues around family law where women's migration status is used against them, for example. So, for example, if a woman's right to stay in this country is dependent on having British children, then the perpetrator might use that to try to get custody of the children and take them out of the country. I've got one case where they keep going back to court, keep saying, I want to take them out of the country. And he knows that as soon as he does that, she will lose her right to stay in this country. The other area is around both systems, the criminal and the family system, do not understand issues around honor-based abuse at all. It's always missed by both of them. And I think that, we've got a case currently going through the family courts where a woman has been forced to go to court because her husband has applied for contact with the children. She had escaped him. He had hired a private detective to find her. And even the private detective had to go to the police and said she was a high-risk case. But anyway, the court, she didn't want to go to court, but she's been forced into a situation and she doesn't want to disclose any information because anything she tells the court will really increase the risk to her. And at the moment, there is this discussions about what can or can't be disclosed to the other party. And I think there needs to be more guidance or understandings around honor-based violence, guidance, but also training, of course, which there has a better understanding of things like honor-based violence from the courts. I just want to say one thing that Claire said. I might have misunderstood this, but you said that you wanted that if the perpetrator kills the victim, then they have no rights over the children. What happens if a woman is being abused to kill the husband, right, father? I know she may be still locked up as the perpetrator and still lose the rights of her children unless you're successful on appeal. We know that she's actually a victim, but the system doesn't quite understand that yet fully. Just need to think about where women are driven to kill as a victim of abuse. Just need to think that, the impact of that.
Hannah, thank you so much. I could listen to you talk for a longer time, but I have to cut this short because Charlotte, you're up. As a barrister, you're well placed to consider the family court and domestic abuse. Please, the floor is yours.
Thank you very much. Well, thank you to all of the speakers as well, and for hearing your contribution, your own experiences of the family justice system from survivors' perspectives, because it's incredibly important, I think, for advocates like myself and others to know what's going on the ground for victims, because obviously we see them in court, we don't see necessarily the holistic picture of all the challenges as well with immigration and with housing and benefits and, the bureaucracy and the other layers of inequality and oppression they're experiencing through that system. So I thank the speakers for highlighting those issues as well as the compounding issues within the criminal justice system, because the vast majority of my clients will have reported to the police, and the vast majority of cases there's no further action, or even where there is a prosecution and conviction, they'll still find themselves in the family courts if they have children, and then experience a re-traumatization and re-victimization all over again. So I wanted to speak about a couple of themes, conscious I've only got 10 minutes. And the first one would be special measures. So Section 63 of the Domestic Abuse Act 2021, coupled with the family procedure rules, makes very clear that there must be special measures in place where a complainant or victim, if found to be true on her allegations, is considered vulnerable in the family courts. And so there must be a ground rules hearing. So that means a hearing to determine what special measures, or as we call them in the family courts, participation directions, are required to assist them to properly participate in the hearing and give their best evidence. And unfortunately, we know that despite legislation and the procedure rules and Women's Aid and other organisations drawing attention to this, along with Rights of Women, Southall Black Sisters, this is still not happening in the family courts. I've represented more than 6 women, but I can only talk about the 6 cases because they've been published, where there have been successful appeals because there has been no special measures. In one case, the victim was directly cross-examined by the perpetrator. So he was allowed to put to her that she was a liar, which she said was obviously not true, and gaslight her all over again. The judge allowed that to happen. In another case, the rape victim was giving evidence, and the rapist, I can say that now, but at the time, of course, accused, he was watching her on the camera, and he asked the judge for the camera to be positioned so he could directly see her when she was giving evidence. That was successfully appealed. And I just won another appeal today, again, 13th of March 2023, this is still happening, where the rape victim had no special measures and was encouraged by the judge after the fact-find hearing to speak to her, the rapist, in the court hearing and negotiate contact. So the victim and the rapist, I mean, it's just beggars belief. So, you know, we're on now 7 from today, and I can say that because it was in open court, and that will be a published judgment, where this is still happening time and time again, which leaves women like today intimidated, frightened and distressed by the process. And this should not be happening. They are simple measures. They're not even expensive to put in place to make sure the victims can participate without that fear and distress. So that's the first issue. The second is that we need a more joined up process. So we need to think, in my view, when findings are made in the family courts, we need to look at the perpetrators and what jobs they are doing, whether voluntary or being paid. So there was a recent case this month where I represented a victim of domestic abuse where the father broke her hand. The father is a senior social worker, and the issue was whether the family court judgment setting out the findings should be disclosed to Social Work England so they could properly investigate. Of course, the father opposed that, and the judge made an order that Social Work England shouldn't see the judgment. So the mother had to appeal. Social Work England didn't appeal. It was the onus was put on the vulnerable victim when it shouldn't have been. It should have been on the regulatory body. She won that appeal. The judgment's been sent to Social Work England. But there are other cases that many of us will be aware of where the perpetrator may be a police officer, there might be a teacher, they might be working in the armed forces, they may be nurses, doctors working with vulnerable people, and we need a joined up approach in making sure that when findings of this nature are made and they are likely to be coming into contact or working with vulnerable people, that those findings are disclosed to make sure they're safe. And I need not remind anybody of the course of the case of David Carrick, but he is one example of many others where agencies and bodies are aware of the fact that individuals are working with vulnerable people and using their positions of power and trust to continue perpetrating that abuse. We need to acknowledge that and recognise it as a pattern of behaviour. We need to bring this to the attention of the family courts. So that's the second issue. And the third one is that whilst I think we've come fairly far with the work that we've all been doing in the family courts, obviously we haven't finished that work by any stretch of the imagination, but in recognising that rape and domestic abuse needs to be, and coercive control needs to be properly addressed within fact-find hearings. And there is now an entire process and Practice Direction 12J that needs to be followed and addressed. What's missing is the next stage. When those findings are made, what happens next? How do we assess the risk of harm caused by the abusive parent to the child survivor and the parent survivor, often the mother survivor? And what usually and sometimes can happen is that you can get findings of rape, as happened in the case of now Kate Nivton MP, but was Kate Griffiths MP, and I represented her. She got findings of rape. Despite that, the judge still continued to order that supervised contact in a contact centre, which led her to, I think rightly, to ask, well, what was the point in going for a fact-find hearing if he was going to get contact anyway? Many people will be aware of the case of HN and others, and one of the linked appeals where I represented the mother in BB, the judge said to this mother, fact-find hearings are a complete waste of time because there'll be contact come what may. I'm paraphrasing what the judge said. It transpired after she won that appeal and there was a retrial, she was found to be a victim of rape and the father does not have any contact. We need to acknowledge, and those working in the judiciary and family law professionals across the board, the real harm caused by domestic abuse and rape, so that we're not just having the isolated fact-find hearing, but then there are consequences for contact. I think it is right, in my view, that there should be a presumption of no contact in cases where there is found to be rape or even domestic abuse, but certainly rape, because it's a heinous act to commit against a woman. And my real concern is, and nobody's addressing this, is the psychological impact on that child of being forced into a relationship with their rapist father, and later in life, they might be 3 now, but when they are 20 and discover that fact, how on earth are they going to feel about their identity and their attachment to their rapist father and knowing what they've done to their mother? And nobody is looking at that from that perspective in the courtrooms. Maybe that as child psychologist needs to address this. But we only need to remember, of course, the rape conception case of the woman who called herself Daisy. I don't know her real name, and rightly she's chosen to be anonymous. But she actually lobbied the CPS and the DPP and others to prosecute her father after he was found, and indeed did, rape her mother. She was conceived and then adopted. Now, in the family courts, if she hadn't have been adopted and perhaps stayed with her mother, she probably would have been ordered to have some form of contact with her father. Now, that was the child that made that prosecution and conviction happen, because that is the draconian, horrendous impact of that rape. That child is also a victim, in my view, both directly and indirectly. So I think we need to readdress the impact of domestic abuse and rape on children's lives, as well as parent survivors. That's my 9 to 10 minutes, so I will leave it there, but I'm afraid I am going to have to go because I'm actually on holiday and I wanted to come and speak with you all now. So I'm sorry about that, but I'll be in a lot of trouble with my family if I don't go.
Charlotte, totally understandable. Thank you so much for giving us your time this evening
Thank
for
you.
keeping to time with your presentation. Thank you very much.
Thank you all very much for the amazing work that you do. And if I can help in any way, my door is always open.
Right. Next up, I have Mandip. Mandip, you propose to look at the barriers women face when representing themselves in court and the experience of litigants in person during domestic violence cases. The floor is yours.
Thank you. Yeah, so there's quite a few of us talking about the family courts and the family justice system today, understandably. And what I wanted to focus on is specifically their experiences with and without lawyers. And also to make the point that one of the most important things that we do at Rights of Women to help elevate women's voices is just to listen to them. Because they don't feel like they're being heard by professionals in the justice system. So unsurprisingly, a lot of the women that contact us are litigants in person, as you've already explained. So people who are thinking about starting legal proceedings or are involved in legal proceedings without the help of lawyers. And the family justice system is built around the concept that we have a judge, an applicant with a lawyer, and a respondent with a lawyer. It's not designed around the needs, the knowledge, and the skills of a litigant in person. And I think we as professionals in the justice system can take for granted the knowledge that we've built up over the years on communicating with the courts and getting ourselves heard. So knowing what points to make to the court, when to make them, and how to make those points is something that we, it's second nature to us, but it's a huge mystery for many of the women that we talk to. And for our callers, just to put this into context, one recurring issue that litigants in person are having to deal with are problems in relation to writing up court orders. So for example, in a child arrangements case, a woman attends a hearing and the judge makes an interim order for indirect contact between the father and the child. The lawyer for the father then writes up the order after the hearing and sends it to the judge to approve, and has included video calls as part of the contact arrangements. And the callers told us that she opposed video calls. She doesn't think it will be safe for her or for her child. And as far as she's aware, the judge decided that video calls should not be included in the contact or in the child arrangements order. And she doesn't understand parts of the order that's been written up. She doesn't know how to tell the court that the lawyer has put the wrong things in the order. She's raised it with the lawyer directly, but the lawyer disagrees with her interpretation of the order the judge has made. She's been trying to get in touch with the court, but it's not getting a response from anyone. She wasn't copied into the lawyer to the email the lawyer sent directly to the judge. And it's been weeks since the hearing and she still doesn't have the order. In the meantime, the father's solicitor is threatening to start enforcement proceedings if she doesn't allow contact to take place over video calls. The reason I've highlighted this is because there's a whole host of issues that this woman is having to contend with. The fact that she's a litigant in person means that she doesn't feel confident she understood the order the judge made and is unsure about challenging the father's lawyer. The lawyer has information and tools that she doesn't. For example, the lawyer's got direct communication with the judge. She doesn't know how to do that. And these are issues that any litigant in person would find difficult to manage. But to add to this, she's a survivor of domestic abuse. So there's the potential that the video call will harm her and harm her child and put their safety at risk. And there's also the power dynamics the power dynamics that were present as part of the abuse that was perpetrated against her by the father are present again here, with the lawyer and the father using their position to threaten and exert their power over and adding to her trauma. So one of the things that we try to do at Rights of Women, similar to support through court, through our advice lines, is that we listen to women, we help to distill what they want to say to the courts and guide them through how to do this. It sounds really simple, but it's one of the most important things that we do to help women have their voices heard in court. We've also got a range of legal guides on our website aimed at survivors of domestic abuse who are litigants in person. We also recognise the role that independent domestic violence advisors and other frontline domestic abuse services play in ensuring the safety of survivors going through court proceedings, as Hannana was just talking about. And this event will hopefully show that listening to and supporting frontline services is itself elevating the voices for women and inspires change. That's one of the things that Rights of Women aims to do as part of the Flows Forum. So a Flows Forum is an online discussion forum hosted by Rights of Women to discuss family law and criminal law issues in the context of violence against women and girls. Membership is open to all frontline domestic abuse support services, as well as lawyers and other professionals that support women survivors. I wanted to also mention legal aid. So one potential solution for litigants in person is to increase the availability of legal aid. Legal aid is available for most family law issues where the person applying for legal aid has experienced domestic abuse from the other party. So you'd think that most of the women who call our advice lines would be eligible, but to access legal aid, you need to pass a very strict financial means test, which means that people with very little or no disposable income and capital are still deemed ineligible. The means test has been under review by the government for some time now. The government did consult on changes to the means test, which would increase the number of women who will be eligible, but progress appears to have stalled on that. And even with the new means test, there will still be survivors of domestic abuse who won't be financially eligible for legal aid, but can't afford to pay privately. The other issue in relation to legal aid that is very important not to overlook, it's not just the number of women who are eligible for legal aid, but also the number of legal aid law firms that exist to take on the work and do it well. If legal aid lawyers aren't paid sufficiently to break even, then this has an impact on the quality of the work, and some of them have stopped doing it altogether. And this is having an impact on the survivors that we speak to on our advice lines, who are either struggling to find legal aid lawyers to take on their case, and those who have lawyers are telling us that their lawyer is never available to talk to them and isn't responding to their messages. And so sadly, one of the reasons callers to our family law advice line are so appreciative of the fact that they've spoken to us is because they're not able to get hold of the lawyer that's meant to be advising them and representing them. Legal aid isn't the only reason though. Not all of the issues that our callers are having to deal with their lawyers can be put down to resourcing and the lack of legal aid funding. As a few people have already touched upon, there is a culture within the family courts which prioritises contact with fathers over the risks associated with domestic abuse, and the impact of domestic abuse is minimised and overlooked. And this was highlighted in the report by the Harm Panel in 2020, which assessed the risk of harm to children and parents in private law children cases. What I wanted to emphasise is specifically how that culture manifests in the service that women receive from their lawyers. What we found is that this culture of minimising domestic abuse, coupled with the lack of understanding around domestic abuse, has a very direct and serious impact on a survivor's voice. It's worrying the number of times we have heard that survivors have been advised not to raise domestic abuse by their own lawyers due to fears that this will make the mother appear unreasonable, or she'll be, as others have suggested, accused of parental alienation, or just because the lawyer fails to understand why the domestic abuse is relevant to the decision that the judge has to make.
And you have 2 minutes.
Oh, okay. So, I mean, don't get me wrong, there's some really excellent lawyers out there who do understand the impact of domestic abuse. They're providing services in a trauma-informed way and make, a really positive difference to the lives of women and their children. However, I would say that there is generally, as a profession, there is room for improvement, and that's evident from the harm report. When callers tell us how much they appreciate us listening to them, they often talk about feeling understood by us, and they mention our patience and the non-judgmental tone of the advisor's voice. I think it's so important for lawyers in practice to hear that and think about whether their clients can say the same about them, and if not, do something about it. In order for us to advocate for our clients, we have to be able to understand them, and in order to understand them, we need to understand domestic abuse and understand trauma. This isn't something that's taught to us as part of our legal training, but it should be. I agree with Hannana's comments in relation to judges and their understanding of domestic abuse, and I would extend that to lawyers as well. The lawyers of today, I often say this, the lawyers of today are the judges of tomorrow. So it's really important that's included in our training. I wanted to end on something a bit more promising. Last year, as a result of the findings of the Harm Panel, the Ministry of Justice launched 2 pilots, which are testing a new approach to hearing cases about child arrangements where domestic abuse is alleged. The pilots are in North Wales and Dorset, and they're called the Pathfinder pilots. They're designed around a set of principles that will hopefully address many of the concerns that we've been highlighting today. So they'll be more trauma-informed, they'll hopefully be properly resourced, there'll be a coordinated approach with information sharing between agencies such as police, local authorities and courts, and there'll be a problem-solving approach. So the courts will be gathering as much information as possible, with the judge taking a more leading inquisitorial role to finding solutions for families instead of the current adversarial process, which disadvantages litigants in person and is harmful for survivors and children. So we are optimistic about these pilots. We hope that any positives from the pilots are shared as widely as possible and replicated, and achieve a safer justice system for women and their children. Sorry, I rushed it a bit there to keep within the 2 minutes.
No, thank you, Mandip. That was great. Thank you very much. I gotta say, I love the fact that everybody is putting at the end of their speeches what they're looking for the future and any positives that can come out of this. So thank you for doing that, because it's always nice to have that kind of, this is what we need to be doing. Last, Lucy, I've kept you for last because you said you wanted to look at how survivors and women's organizations have driven positive changes to improve access to justice. And I always like to finish on a more positive note. So this is why I've kept you till the end. Thank you.
Thank you very much. Yeah, it's been great to hear from everyone tonight. Lots of common issues and challenges, but obviously updates on some of the positive changes that we've seen and we've worked on together over the past few years. I wanted to start by kind of talking a bit about Women's Aid's work in the family court response to domestic abuse. So when I started working at Women's Aid nearly 7 years ago now, we just launched our campaign, Child First, Safe Child Contact Saves Lives. And we launched that following feedback from survivors that the safety of the family court system and the safety of child contact were the #1 issue that survivors wanted us to focus on at Women's Aid. And I'm sorry to say that although we've experienced some kind of huge political, economic changes, a pandemic, Brexit, lots of other huge events that none of us predicted in the past 7 years, absolutely nothing has changed in terms of survivors raising the family courts as one of their foremost concerns that they want reform on. So we have, and I'm going to talk about some of the changes that we've seen through the campaign and through the work of many in the domestic abuse sector, and we've definitely seen some positive changes, but unfortunately the #1 issue that women get in contact with us about is their experiences of harm and abuse within the family court proceedings. And I think one of the reasons for that is that you might feel that once you've escaped domestic abuse, that's the beginning of your recovery. You've found freedom and independence from an abuser, but I think what women find with the family court system is that it throws them back into every experience of abuse and control. Sometimes, and many women have said this to us, that it's worse than the abusive relationship itself, because it's compounded by the treatment within the family court itself. I think as women and as a mother now myself, I find reading and talking to women about these experiences of domestic abuse in the family courts incredibly harrowing and traumatic, and I'm sure that many on the call through your volunteering work with Support Through Court have found the same. As one woman recently told us, the mantra of her experience is everything that could go wrong went wrong. Every single step of the way has been horrible and expensive. There have been zero consequences for this man. He continues to emotionally harm our child and puts him at risk of physical harm. The family court system is absolutely Byzantine and terrible for women and children. It's been the worst experience of my life, a dystopian horror compounded by the COVID pandemic and being completely isolated with no support. As Mandip mentioned, there was an expert panel coordinated by the Ministry of Justice on assessing harm to children and parents in private law children cases, which published its final report in 2020, and Women's Aid sat on that expert panel. And it set out really clearly, we felt, the scale and the range of the issues facing women and children experiencing domestic abuse in the family courts. And we felt really hopeful with this report because it was finally kind of official government recognition that the system was failing survivors and needs a complete overhaul. We've talked about many of the themes that the report delivered conclusions on already, but particularly it talks about the pro-contact culture and how this minimises the impact of domestic abuse on their parents and children. It talked about an adversarial process of reaching child contact agreements. It talked about the lack of resources which affect fact-finding and the quality of risk assessment and severe issues for litigants in person. and talked about siloed working, so a real lack of coordination between fact-finding in the family courts and then other proceedings that survivors might be involved in, whether that's the criminal justice system, social services, and other public services that they've reported to. Though sadly, despite these kind of really important conclusions and really important recommendations of the panel for what needs to change, we have felt that progress in reform has really stalled. And we've seen a catalogue of kind of wider challenges and resource constraints, which too often we feel lead to dangerous and unsafe responses to women and children experiencing domestic abuse. The urgent review of the presumption of parental involvement, which Claire mentioned earlier. So the panel recommended that presumption was urgently reviewed. Unfortunately, that review is still ongoing after 2 years. And this, we feel, is one of the biggest barriers to ensuring safe child contact in cases of domestic abuse. I think it can be really difficult to remain positive and to keep pushing for change. We got this really landmark, important report. We got a number of different changes, such as a ban on cross-examination in the family courts through the Domestic Abuse Act, a guarantee of special measures in the family and civil courts, as well as in the criminal courts. But as Charlotte mentioned, some of those things that we've achieved in law haven't necessarily changed practice on the ground. So it can be difficult to kind of remain positive and optimistic. But I do want to just end by looking at where we have seen positive changes and reflecting on the fact that this has been hard won and fought for by women, including women here. So we've already mentioned, both Olive and Mandip mentioned the landmark ruling following the long-running campaign by Latin American Women's Aid, a service led by and for Latin American women who were represented by Charlotte, where the High Court ruled that personal service of a court order should never happen in a refuge building. And you'd hope that would be common sense, but that's taken a long time to secure. I also think about the many survivors that we work with who've had truly horrific experiences within the family courts, but continue to want to speak out and campaign for change for others. And I don't think there's anything more powerful than that. Particularly, I'm thinking of our survivor ambassador, Claire Waxman, whose sons, Jack and Paul, were killed by their abusive father on an unsupervised contact visit. And despite her loss and the unimaginable trauma of that, she continues to fight for a better family justice system that keeps other women and children safe. And if you look up Claire Waxman on Twitter, you can find a really powerful video about why she started to campaign and what she's done for reforming the family court response to domestic abuse over the past couple of years. And of course, the many on this call who volunteer for support through court every day and help people navigate the court system when they're experiencing really difficult situations and ongoing abuse and trauma. So yeah, thank you for all of that work, and thanks to everyone on the call that does so much for improving the response of the family court to women and children.
Thank you very much, Lucy. Thank you, everyone, for your really interesting presentations, discussions, and also thank you for mentioning what you think needs to happen next, what needs to be addressed, what work needs to happen to continue supporting and elevating women's voices as they're going through the justice system. That's been amazing. I'd like to open panel up to questions. Anybody would like to, any member of the audience would like to raise questions of the panel, please do so. If any of the panelists have questions of each other, then please do so. Please ask each other questions. You all know each other, so it might not be, you might already have answered all each other's questions. There is one message. There's a question in the Q&A, let's see. Someone has posted a message. I don't know if it's a question, but it is a message which states, it's from an anonymous attendee, who says that they feel that going through the court system, whether it's the courts, the clerks at courts, they feel like they're going through the whole abuse all over again. And they mention how the clerks of court had to insist on the victim's rights from cross-examination, as they initially refused special measures and there were no consequences for the perpetrator. It is something that really is continuing to happen, and it is what you are all working hard to try to address. Do you have anything else you'd like to raise? Anything else you'd like to mention? Positive, negative, future looking?
I'll ask a question to Claire if no one's got one.
Go on.
Thank you for raising the issues around, lawyers, independent legal advice for survivors of sexual violence is something that, quite rights women, and as you know, a lot of organisations are concerned about. I was just wondering if you knew kind of appetite there was to bring about these kind of changes with the, the Victims Bill hopefully coming soon, and do you know when the Victim Bill might be introduced?
The question that everyone wants the answer to. We had hoped last week, or not last week, just on Friday, and Hannana kindly came to speak at the London Victims Summit. We were hoping that the minister who came, Ed Argar, would answer that question, but he didn't, did he, Hannana? He still, we still haven't got it. It's always imminent, but it's been imminent for about the last 18 months. So I don't know. I also don't know what the appetite is for the legal independent representation. I have put it in strongly in submissions when I was in front of the Justice Committee, and in submissions, and others have as well. But we'll have to see what they're going to incorporate in the new bill when it comes back. If it is not in there, then it's something that one, and I think quite a few of us, will be strongly campaigning for. Because, as I mentioned, sorry, just briefly, because that extraction code that came through the policing bill, whilst that is a positive, you have to have that mechanism of that legal independent support, as you know, to make sure that the police and the CPS are actually adhering to that code, and the requests for the data is strictly necessary and proportionate. And we can't just leave that in the hands of the police and the CPS. You absolutely need someone to support the victim through that process as well, because how will they know what's proportionate and what's strictly necessary?
Well, we don't seem to have any other questions, and it is 7:30. I think we probably all have something else we need to be doing, and I've taken up enough of your time, so thank you so much. I'd like to thank Lucy, Charlotte, Mandip, Hannana, and Claire all over again for amazing debate, discussion. I'm a family law solicitor, and I have worked and done some of the things you're talking about, but it was an eye-opener for me to hear a lot of what you're saying, because I don't come across this necessarily day in, day out. So thank you very much for all of that. I'd also like to thank Support Through Court for organizing this, what was essentially a fundraising event. As a charity, they rely on the generous donations of others. Without this, they would not be able to provide the vital service that they provide, and demand keeps growing, and it will no doubt keep growing. Donating £35 can support one client at an in-person appointment. What's more, becoming a regular donor with the Champions Network ensures long-term support for their volunteers, and that it gets in person. For as little as £5 a month, you can help bring about the change that they seek to do. It's a great charity. Silly thing to say, but I'm looking forward to retiring so that I can actually go and volunteer with them, because I would love to actually be on the ground and do the work they're doing, but as a practicing solicitor, I cannot. So all I can do is fundraise and support them. They are very helpful, and if you do work in the court system, you'll know the kind of support and help they provide, even if it is just lending an ear and trying to provide emotional support to someone going through the court process. But there are many other charities that we have here today on the screen who have also do amazing work, and I think together we're all supporting the same people. So let's carry on doing that. Thank you very much, Lucy, Hannana, Mandip, Claire, and Support Through Court. Celine, we can't see you, but thank you very much for thinking of this and for putting it together and getting us all together on a Monday night to discuss this. Thank you very much. Thank you. Oh, wait, hold on. I see multiple questions. No, it's all thank yous. So here we are. Thank you very much, everybody. Have a good evening. Thank you.
Thank you.
Thanks, everyone. Bye.
Bye.